Good afternoon, everyone. For those who don't know me, my name is Noel Devons. I'm the chairperson of Foyle Ireland, and we're delighted to have you all here today on what was anyway a very, very miserable day out there. I've been in a taxi for quite a bit of it, and at least it's clearing up now, so that's not too bad. But anyway, I suppose the purpose of today really is we haven't had an in-person CPD event in, I believe it's 2.5 years now at this point, and I think the last one may not have been in this room. It was the last one plus one was in this room. And while it's great to do CPDs on a monthly or bi-monthly basis, it is important for us all to get here as members of Foyle, meet each other, have the various chats and make sure that we catch up with each other in person and just have that as a breeding ground for ideas and thoughts and everything else. So that's the purpose of having the CPD event here today. We are planning on having more of these in-person CPD events, and certainly we will have one long before 2.5 years pass again. We'll also have a number of other events that will be happening online over the next number of months, so watch that space. So today we have 3 speakers in relation to 3 different topics, 2 of whom are here at the moment, and we are very much hoping that the third person will arrive before his time to speak. So we have Nora Hughes, she's the legal director at Hughes Flynn Legal Cost Accountants and has been for 11 years. She's here to talk to us in relation to the issue of legal costs and how we can attempt to reduce the plaintiff's legal costs claim at the end of any particular case. So I'm sure those tips and tricks and everything else will be very much appreciated by the individuals in this room. We also have Gillian O'Hanlon, Junior Counsel, who will be dealing with the Germain versus Day nervous shock case and giving pointers in relation to that. And lastly, we have Jeremy Maher, Senior Counsel, who will be dealing with judicial or the personal injuries guidelines in terms of monies to be paid in relation to various different injuries and the recent Supreme Court case in relation to that. So I'm sure it'll all be very interesting, and we are going to go with a question session at the end of the 3 speakers. So if you have any questions, queries, comments or anything like that, please get them ready and have them available at the end. Lastly, before I introduce or bring on our first speaker, I might ask you to turn off your phones or turn them to silent or whatever. Just make sure we have no serious interruptions. So without further ado, I'll ask Nora to come to the podium. Thank you.
Now, hi. I had started off, I suppose, going into the Legal Services Regulation Act, but I don't want to bore the lot of you. So what I will start with is how bills are done now. You probably all notice that bills are done differently. They're done in 4 sections. So previously you had one bill and one figure put in it for the solicitor's instructions fee. Now that's all gone. It's the same now for the High Court and the Circuit Court. So bear in mind the Circuit Court bills as well are changing. So you have Section A is pre-proceedings. So that's all work from the date the client went into the office up to the day before proceedings are issued. So then you have Section B, and then that's from the date of proceedings up to the day for the hearing or negotiations, whichever one applies. And then you have Section C, and that's your day at hearing or negotiations. And then you have Section D, which this is the whole new part in it. This is where you have all your costs from the date the matter concluded up to the finalisation until you take up your certificate of adjudication. So you will see costs now have creeped up slowly, especially more so, I suppose, you noticed it probably in the Circuit Court than the High Court cases because of these 4 sections. Now, originally the Circuit County Registrars were dealing with it on summary bills, but now they've gone into they're adopting the same approach. It has to be detailed bills of costs. So I just want to touch on that because you're probably aware these bills now broken down into 4 sections. But from a defence point of view, if you are still making offers, a lot of the time people prefer a global fee. If you're offering on say an instructions fee, to offer a global fee rather than break it down, because everyone is still, I suppose, the old frame mind of say a solicitor's instructions fee. Just want to touch then briefly on the District Court. You're probably all aware the increase in the District Court rules 2023. Just bear in mind that there's a lot more fees added in now for counsel, whereas they weren't in the old District Court. But from a defence point of view, bear in mind, it has to be certified. So ensure when you see your order coming in, a lot of it has to be certified. Council's fees have to be certified in it. Now, there is a provision in it, Order 53, Rule 3, basically where a party intends to apply for costs otherwise in accordance with the schedule of costs, that party must be available in court any information or document which establishes the special circumstances in which to support such an application. So if you're, even if from a defence point of view, if you're successful in your case and you have an engineer, make sure you have your fee note there and you get it certified. And you can get it measured there and then by the judge as well. It's just, it's at the, when it comes to conclusion of the case to, I suppose, fine tune it, especially if from a defence point of view, the plaintiff's costs struck out and you recover your costs. Try and have the scale with you there and then and get the judge to measure it, because there is no avenue to go anywhere on district court costs because the scale is there, and there is disputes starting to rise now where they're saying it wasn't certified, you need your engineer certified, and then the quantum of engineer, you need to nearly get it measured there and then rather than leave it, because there's nowhere really to go after that bar back to the judge. Then just hitting on the circuit court rules, tender. Always keep saying on costs in the circuit court, that's Order 66, Rule 8. So basically that's a party to whom such a bill has been furnished may tender a sum of money in discharge of such bill, and if such tender is refused, and that amount of such bill when taxed shall not exceed the sum tendered, the cost of taxation shall be borne by the party claiming on foot of such bill. So we always say, most circuit court cases, tender on the costs. When you get the bill in, even get advices, but always tender. Just don't give them a free run of the taxation. Always say, to add on to the end of it, that letter when you're sending out the tender, if the cheque is cashed, it's deemed to be accepted in full and final settlement. So just to remember that, because a lot of times, sometimes the solicitor might cash the cheque and you think it's right, that's it, done, close the file, and next thing you get a taxation date. So just to copper fasten it again as well, just put it at the end of it, if the cheque is cashed, it's deemed to be accepted in full and final settlement. Then briefly going to hit into the High Court. Now, you're probably all aware now there's tenders in the High Court. Now, this is the best welcome from Doom Defence point of view. I'd say the amount of cases now that aren't going to adjudication because of the tenders. Now, they're broken down differently. A circuit court tender is completely different to the High Court. The High Court's broken down, it's professional fees, then you have senior counsel, junior counsel, and then your disbursements. So it's broken down into 4 sections. Again, what you really need to pay heed to is, once you get the date, you have 21 days in which to serve your tender. So you need to move straight away. As soon as you get in notice of taxation or adjudication, you need to move on it. Don't sit in it. Whatever you do, get instructions or get advice from a cost accountant, but move on it. Now, you can make an application to court to extend that time, but it just saves hassle. So always bear in mind, once you get in notice of adjudication, instruct a cost accountant or get advice from cost accountant and get your tender in. Now, they have 14 days on which to accept that tender. Look, I haven't seen anyone stick to it, but it's one worth, I suppose from a defence point of view, if you serve it and you're saying, right, I'm giving you 14 days, I'm sticking to this, you either accept it, but we have to instruct a cost accountant, that tender no longer is applicable. So just to bear that in mind, but I would say if you are doing that, just to remind the plaintiff solicitors of that. As well, actually, the adjudicators, you can now get a lot of the decisions from the High Court adjudicators online. So it's just good to note yourselves if you want to just check up and see it, because it's broken down and they do give good detail written, on the costs, and they'll break it down into each section. Then just want to focus on, I suppose, cost saving tips. Motions. If you're successful as a defendant, make sure, do you know what, sometimes the judge will reserve the costs. Whatever you do, reserve the costs to the defendant only. The amount of cases I see coming in where the motion, the costs are reserved, and then when it comes to conclusion of the case, this could be 8 years later, you'll see then costs reserved and automatically goes into the order, reserve cost discovery. Next thing, the plaintiffs are covering the cost, that motion that you had to issue, maybe to compel them to reply to particulars where it was reserved. So just to bear in mind, when you get to that stage, reserve them to the defendant only. Then also, if the plaintiff is awarded costs, make sure there's a stay. Put a stay on it to the conclusion of the proceedings, because a lot of the time a solicitor will go ahead, and bear in mind, if solicitor goes ahead with that motion now, that's broken down into the sections. So you have section B, So that with your motion, your section C, attend in court, and then your section D for preparation of the bill. So it's very important, whatever you do during the case, is to make sure that there's a stay put on that. And also, actually, if you get your costs of a motion during the course of proceedings, use it as a bargaining tool at the end of the case. If the plaintiff has a motion as well, just keep it at the frame of mind. A lot of the time they'll forgo the cost, or you set off each motion against each other at conclusion. It's just, you can see the fees increase, and also it keeps it communicate. You'd often see on files 3, 4, 5 warning letters go out, and then they issue the motion, and then they communicate. It's too late then. If you can at all communicate, once they start issuing warning letters, if you need more time, a lot of the time solicitors will hold off issuing a motion rather than incurring them costs. So a lot of the time I say, just, I suppose, pick up the phone, ask them, or send a letter just saying, look, we need more time, will you hold off issuing a motion? Then I suppose the whole engaging unnecessary witnesses. If you're aware during a case, if a plaintiff solicitors has a number of experts, and then you get in your disclosure notice and you realise half them experts aren't in it, start the ball rolling for us. Just say, even a letter to them saying, I note that X, Y and Z aren't mentioned in your disclosure notice. On that basis, we would be objecting to them on adjudication. It's just so we've something to start off when we're there going, actually, we've already made them aware of this. They've been made aware that these experts, not in the disclosure notice, therefore we're not charging their fees. So again, it's just to keep an eye on it. Minor as well, I just want to point out that if you have a case where it's a minor and you have a hearing date, rule it that day. If you can at all avoid bringing a motion to rule, let it go in on that day, because you're just increasing the cost. You may have a hearing date, so you're paying a brief and then a ruling fee. So just say, look, it can be ruled on that day before a judge, if you can at all. And I know, look, as you're not present, maybe the PIAB costs still creeping in on circuit court orders. Some of the circuit court judges are giving costs of PIAB. But if you've even a letter, say if you settle it and it's put on negotiations, your letter going out going, but we're not paying any cost of PIAB. So just have it in correspondence there, so we can, even if the judge gives it, we say, well, we're going back into court, part of the agreement was there'd be no cost of PIAB. It's just, it's still creeping in on orders. We still see it coming in from very different areas. Then attendance notes. Can't emphasise how important these are, especially for negotiations. You probably all had it there, where somebody turns up to negotiations. Next thing, counsel's brought in at the last minute, realises they need an awful lot more reports, and they're like, we can't negotiate. Have an attendance note. Make sure that they walked away, that they didn't negotiate. Or look, if they come in looking for 2 million and it's settled for 40,000, for me, if I'm in adjudication, I need something backing that up. If there's an attendance note on the file and I'm reading it out and going, well, look, actually, they did look for 2 million. We tried to be more pragmatic. We offered 30,000, settled for 40. We don't believe that's reasonable on a party basis. Them costs should be deducted. And they will take that into consideration, but we need backup. We need something on the file. There's no point, after the event, you might get a letter from the solicitor, but if you have an attendance note on it, it definitely works way more, especially on adjudication. Extra days in court, again, same thing. If you can more so keep a note of the experts who are in attendance, if you can. Like, look, I know it's not sometimes possible, but if you can even keep a note of who was in attendance, because a lot of the time we'd have, you might have a GP's attendance, and they say, oh, well, he was on his way to court, and they're looking for a full day's €1,000. But if we've something like going, well, actually, the solicitor has an attendance note here of who was present, there's no mention of the GP, and then they'll disclose going, oh, well, they're on their way to court. That means they'll get a half day. So you can manage over a year, that can reduce down the cost significantly. Then I suppose if you're settling a case, orders. Lately, orders are, I'll give an example there. One I had where it settled at defence stage, the agreed briefs out basis, nothing wrong, but on the basis of a 1-day hearing. Now, I wasn't even set down for trial, but that's what the solicitor, and I suppose everyone was, excited, got it all done and dusted, and went with that order. So you're looking at a case settling at defence stage, briefs out, that's nothing wrong with that, but on the basis of a 1-day hearing. So just be careful of what you're agreeing on the day with regard to costs. What sometimes I say is, if you could, that's it, say if you settle at defence stage, try and agree counsel's brief there and then if you can. Especially if it's a PI, you all know you'll be very familiar on what it's worth. But if you can agree the brief there and then, that eliminates that from a bill. So from an optics point of view, when we're going in, it more highlights this settled at defence stage. If you can, it's just one way, a tip maybe if you can at all, if it's not set down for trial. Then just discovery, if you can avoid it. Like, look, I know in cases you have to look for it, but if you can avoid it, avoid it. Some cases they go off and look for 5 years medical records. This is an argument, they narrow it down to 3, get in 3 years medical records. You're looking at, just even say for the High Court, that's about €2,000 if it's not necessary. Now I know in some cases it is necessary, they may have had pre-existing injuries, but some cases I see it's not necessary, it's nearly like they go out and look for discovery anyway. But if it's not necessary, try not look for it, because High Court, it's anything between €2,000 to €5,000 extra, depending on the amount of records. But look, if it's higher, it means they have been involved in previous accidents, so you have to take up the discovery. But if you can avoid it at all, do, if it's not necessary. You know yourself from files. Then I suppose from cases, the earlier it settles, I suppose the less the costs. Even the earlier it goes to mediation, the less the costs as well. If you can at all, I suppose get it in as soon as you can. Touching time recording, it isn't the main point now at all. A time recording, if you're relying on it, it has to give a narrative of the work done. It can't just say the date, 2 hours. You have to have a description now of the work done to back up that time recording. So look at it's. I haven't seen many cases yet where they're relying on time recording, but just bear in mind, if you are going to rely on your time recording, that you have a narrative in it, setting out what you did, and then it's 2 hours, talk to the client. You have to have a little bit more detail in it than that. Special damages as well. Just if you see, you get in the updated, say, specials from the plaintiff's solicitors, sometimes you might see medical reports included in there. If they are, leave them in it, and just say agree on an all-inclusive of special damages. If that's the case, then they can't recover them medical reports a second time. So that means if they're in the schedule, sometimes you might highlight it and say the medical reports come out. Just don't say anything. If they're in there, it means that we look at it and we see they've already recovered for that. So that comes out then as well. Then just, I suppose you probably all see independent medicals. Solicitors now looking for the fees up front for the client attends the medicals. This is probably more prominent now because previously the taxi masters used to allow it on a bit of cost, expenses for a plaintiff for attending them independent medicals. Now that used to heighten up the costs, but now they won't allow it at all. So I suppose, look, as you might see, if it comes in any bills you have now, deduct it. It comes out, they're not allowed on a party-in-party basis when it comes to costs. Expert witnesses, just if they're there, I suppose they need to have a more detailed breakdown. I suppose you, from point of view, if you might get in a fee note from some expert, fee for professional services, and could be 10,000 in it. That's no good. You need to know exactly. They need to set out the date upon which the work was carried out, a brief description of the work carried out, the time spent, the identity of the person carrying out the work, and the hourly charge out rate. Now that's the minimum you need. So just bear that in mind. Sometimes you would, I suppose, more complicated cases, they just send in 1 hour. You need to get a breakdown. You need to get a narrative of the work that was done. Another thing, I suppose, to keep cognizant of, if you're coming close to a hearing date and for some reason you have to look for an adjournment, the sooner you get that adjournment, the better, because if a solicitor has already put all these experts on standby, you will have to pay for all that work to take them all off standby and we put them on back on standby again. So the earlier, if you are going to get looking for an adjournment, the earlier you do it, I suppose, look at it, reduce down the costs. I had one there, and it was through no fault of the defence solicitors. They had to seek an adjournment to get more expert reports. But what happened was the solicitor sent over a list of all the standby fees. Now it was a bigger case, more complex case, but sent over a list of all the standby fees, and they agreed it there and then. Some of them experts weren't relied on. So I was trying to say them experts come off because these reports weren't relied on, but we had already agreed these. So just, if a solicitor is doing that, saying no, it'll all be left over to final adjudication of the costs, that you're not going to agree specific figures at that time, that can be done on conclusion, that you're agreeing to their standby fees and leave it at that. It made it impossible trying to get them experts. I'd say there was about 4 of the experts on at the end that they didn't rely on, but they had already agreed to pay them their standby fees at that stage. Just standby fees are about between €300–350. So just to bear that in mind. And look, you'll get up to 2 days notice. You probably see a lot of times as well, GPs put in for locum fees. It normally isn't allowed. If they're on standby and they put in their standby fee and their locum fee, the reason why, say, the adjudicators and county registrars will take them off is because that GP is more than likely in his office working. So on that basis, they take it off rather than allow it. But I do see it coming in more often than not now. They're on fee notes. Attendance fees, just to bear in mind, for day in court expert is minimum 1,000, and it probably works up from that then plus their travel. But it's 1,000 for a day in court for any, I suppose, most experts. Just I keep mentioning again, just as soon as you get in notice of adjudication, so important that you move on it. It's 21 days once you get it in to serve that tender. And you will find a lot of the time the cost counters or the plaintiff solicitors will accept it, because it still has to be copper fastened, but you have to, if they go down on the tender, they pay for the cost of the person opposing that adjudication. Now the court usually, we're waiting on the adjudicator to give us a decision on that, whether that follows as well with it. So that's still not, we're not sure what's going to happen with that. I think he's going to give a decision the next month, he was saying, on it. What I'm going to do is then probably give you brief, I suppose, examples, cases, maybe a 40,000 PI assessment, looking at 3-4 reports. Minimum instructions fee now 13,000. Bear in mind, a lot of the cases now, the county registrars aren't too far different than the adjudicators on the lower end damages. Sometimes you might see the county registrars allowing a bit more. So I suppose bear that in mind as well. Say 20,000 one liability and issue with limited discovery. It's a minimum of 15,000 now on it. Look at in section D in the circuit court, it's about 1,500 for the bill. The adjudicators, they're in around the same when it's the lower end damages to 2,000. So there's not an awful lot of difference now between the circuit court, say, and the high court. In the lower end, say, the high court. Say a high court 60,000 one assessment, you're looking 4 or 5 reports, roughly instructions fee 18,000 there. There's one there, 100,000 liability and issue with limited discovery as well in that. That's, you're looking at €30,000. So they have slightly increased. See, the best example would be motion. Say motion, the circuit court now, motion default to defence, probably about €950. In the high court, it's probably about 1,000. So there's not an awful lot of a difference there in it. Now, I know some of the county registrars measure the motions. Initially, when you look at it, it's normally measured about 1,200. Might seem high, but actually when you break it down, that's all in. That includes your counsel, your stamp, and the solicitor's fees. So when it's measured, it's not as high as you think. So, you know, sometimes if it is measured, you're better off than on conclusion of the case, because that 1,200, I was breaking it down there one day and it worked out the solicitor was getting about €750 plus VAT. So it's not as high as you would think initially when you see it measured. I think 1 or 2 of the county registrars might measure motions. I keep saying avoid them. If you can at all, prevent them and keep a stay on them until conclusion. And if it's your motion, make sure you get your costs reserved to the defendant only. Now, have you any questions?
Dave, you mentioned there, Nora, the creep in professional fees, and some of the professional fees you're obviously quoting there. Like, I would say, and I'm sure other people in this room would agree, that it's not really a creep in the last 4 or 5 years. It's like an outrageous inflation in respect to professional fees. And I think we all accept there has been economic pressures and inflation, and that's how. But the professional fees for solicitors in person reactions have gone way beyond that. And I'm just wondering, what's your perspective on why it's gone that high? Why we've seen, particularly in the circuit, if you talk like an assessment case, and you're talking professional fees of 15k or whatever, that seems insane.
Yeah, as outrageous it might be, the circuit court, a lot of them county registrars now there's a lot of motions to review. So the insurance companies are, I suppose, focused in on that now. So I do think that's going to start creeping a little bit back down. The High Court, I wouldn't say there is a big jump. They're really focusing on the nature and extent of the work done and the complexity. Now, they really do. You will see the difference in precedence. If it's a straightforward assessment, you won't get anything like some solicitors think they will get. It's not too far removed from what we were getting, I suppose, about 6-7 years ago. There may be 1,000, 1,500 added onto it. But in the Circuit Court, there has been a jump, but there is a lot of focus now on it, as in a lot of motions to review, and a lot of the motions to review, the defendants are succeeding and they're reduced, but some of them, they're reducing them down dramatically, which then further on end up going to the High Court. But there is a jump, but I see the Circuit Court is going to start coming down a little bit in the next year, probably.
Robert Kennedy, Nora from Homes. Thanks for breaking my heart when you were for a plaintiff, by the way, in the first instance. But I have a thing that I haven't come across before in the High Court, where the plaintiff is looking for payment of costs on account under Order 19. It's some Practice Direction 71 or something like that. What's your view on that?
That payment on costs, I always say argue it. That was set up. Remember, it was the time where there was a delay.
That's right. Yeah.
There was a delay in adjudications, a delay in decisions. It was taxi masters at the time, wasn't it? So that was set up for that purpose. There is no delay whatsoever. There's a third adjudication now to be appointed. So that was the main basis for that order at the start, was because of the delay. I always say argue it. Argue it, because there is no delay. If the solicitor moves on his file, you can say go to cost count, you have a bill back in say 2 months' time. You can have a set down a date within, like you could have a date for adjudication within the 3 months if you want, less time if you wanted to. So there is no delay. So I always say, I've done a few lectures for them to solicitors to argue it. No, because what I find is sometimes the fear would be that they may sit on the file, that there wouldn't be as much urgency. Whereas they're looking for their fees, they'll move a bit more swiftly. So argue it. I always say argue it. That was set up because of the delays. There's no delays whatsoever now at all. You're getting dates. I think even trying to get dates 3 weeks out, so at least you can tender on the cost, is nearly problematic. So you're getting a date within 6 weeks once you set it down for adjudication. So argue it. Don't,
Yeah, that was my instinct as well.
Yeah.
Well, try to send the bill, obviously.
Yeah.
Thanks, John.
Okay. Oh, that's it. Make a run for it. Thank you. Okay, thanks, Mike. Okay.
Hi everybody, I'm going to talk to you about Germain and Day. That was a judgment from Miss Justice Emily Egan that came out back in July, and it contained somewhat of a clarification about how proximity and the duty of care might apply in cases of nervous shock, particularly in the medical negligence context. The judgment did also reaffirm quite strongly that Kelly and Hennessy is the appropriate test in cases like this, and also that Glencar applies to the 5th criterion of Kelly and Hennessy. So the facts of Germain and Day were obviously unfortunate, but they're quite straightforward in that Mrs. Germain's husband died of lung cancer after a late diagnosis of his condition. The gentleman had an x-ray of his chest in October 2018, and it was misreported upon by the radiologist in St. James's Hospital. And essentially the issue wasn't actually discovered until the man suddenly deteriorated around Christmas of the following year. And on the basis of that, his wife said that she had suffered a nervous shock from witnessing that sudden deterioration in an unprepared manner. And the man subsequently died then Valentine's Day the next year, and the plaintiff issued her proceedings against the hospital. So in Kelly and Hennessy, neither the 1st criterion of the test nor the 4th criterion of the test were an issue. And as such, the court's consideration was really confined to 3 main issues, which were whether the plaintiff had suffered a shocking event, and that's criterion 2, whether if the deceased had been diagnosed in a timely fashion, would the plaintiff have suffered the adjustment disorder that she did suffer, And essentially that was whether the shocking event actually was caused by the breach of duty, and then whether the defendant owed the plaintiff a duty of care to avoid causing her foreseeable injury in the form of a nervous shock, and that was criterion 5. So in respect of criterion 2, which was whether the plaintiff's injury was shock-induced, the court considered all the classic nervous shock cases going back to Gentian Coffey, the Australian case, Fletcher and the Commissioners for Public Works, and Harford and Alcock and the Chief Constable of South Yorkshire. And Miss Justice Emily Egan noted that the shock is pretty much a compound concept, and it requires that the plaintiff suddenly appreciates a horrifying event. And Miss Justice Egan emphasised that what matters is the objective nature of the event and not subjectively how the plaintiff has perceived it. And Judge Egan accepted that there was a dramatic deterioration of the deceased on the evening, and that did shock his wife. And the judge didn't feel a need to adopt an overly restrictive interpretation of the concept in relation to the unfolding of a shocking event over days as opposed to hours. However, the court did highlight that the deceased's deterioration and the plaintiff's appreciation that medical assistance were necessary were part of a gradually unfolding series of events. And as such, it was more of a dawning realisation than a shock. And on that basis, Miss Justice Emily Egan found that it wasn't a shocking event for that purpose. And of course then, the failure to satisfy criterion 2 would have alone been fatal to the plaintiff's claim, but the court did proceed to examine the issue of causation arising under the third criterion also. So the plaintiff, for the purposes of the third criterion, which is essentially causation, was required in line with Quinn and the Midwestern Health Board to establish a but for causation, so that but for the breach of duty that she would not have suffered psychiatric illness complained of. And the defendants in their submissions made a very good point on causation, that even if it were accepted that the plaintiff's injury was caused by witnessing the deceased's demise, that the plaintiff would have witnessed that in any event. And that was true. There was evidence from a consultant oncologist in the case that given the progression of the deceased's illness at the point that it was diagnosed in 2019, essentially an accurate reading of the X-ray wouldn't have actually made any difference. And the court was also presented with evidence to the effect that the plaintiff would have suffered an adjustment disorder from the deceased's death, no matter how or when those symptoms had actually presented themselves, and regardless of whether or not she was actually prepared to experience that. And the court did find it doubtful that a plaintiff could recover damages for psychiatric injury which are consequent on a sudden shocking event which would have occurred irrespective of a breach of duty, and was unconvinced by the argument that even if the deceased's decline was unavoidable, that earlier diagnosis would have ameliorated the manner in which the plaintiff was exposed to that frightening event. And Judge Egan astutely observed that criterion 3 wasn't sufficiently granular to shift the focus from whether a defendant's negligence caused what a plaintiff witnessed to whether it negatively impacted the manner in which it was witnessed. And the court also emphasised that there wasn't actually any evidence that but for the plaintiff witnessing the deceased decline without prior knowledge of the diagnosis, that she wouldn't have suffered the adjustment disorder complained of. And the court just couldn't reconcile the plaintiff's case with the jurisprudence which allowed recovery in nervous shock, which was traditionally like witnessing an accident or coming upon the immediate aftermath of an accident, or witnessing the condition of a family member after an accident. And in all those cases, the shocking event was actually directly caused by the negligence of another. And the court was essentially being asked to infer here that the knowledge of the deceased's terminal diagnosis would have cushioned the plaintiff from the psychological impact of his demise. But Judge Egan did point out that there was no actual evidence to support that it would have cushioned the plaintiff, and therefore, unfortunately, the plaintiff also failed on causation of criterion 3. Now, there was definitely a reticence on part of Miss Justice Egan to consider criterion 5, as she didn't think it was actually necessary to resolve the issues in the case, and certainly to make a determination on the issues involved in criterion 5 would be a massive statement in the law, and would set a precedent from there. But she was more comfortable with outlining the contours of what the future cases that actually involve those issues squarely might discuss. So the court highlighted that there was a very specific duty of care contended for by the plaintiff, and that of course was that there was some kind of a duty on part of the defendant hospital to shield her from witnessing her husband's death in an unprepared manner. And Judge Egan found that that couldn't be made out in any event, as it would be completely unreasonable to impose a duty like that for such an unforeseeable consequence. And the defendant contended as a general proposition that type of a broad-based consideration of proximity needed to be engaged in, and indeed that the plaintiff was merely a bystander in this thing, and that the law didn't preclude recovery for that. And Justice Egan pretty much shut that down instantly and said that bystanders are able to claim in this jurisdiction, unlike in the UK where there's a lot of controls coming from Alcock. The plaintiff then argued for a type of derivative duty of care, where essentially the doctor's duty of care to his patient, to the deceased, emanated from the deceased to the plaintiff. And Judge Egan didn't really entertain that too much, but it was a clever argument in light of the difficulties that the plaintiff had with her case. And in particular, Judge Egan pointed to the fact that the proximity just wasn't framed like that in cases like Gentian Coffee, and emphasised that where psychiatric illness is caused by perceiving consequences of carelessness, it's not sufficient to prove that a defendant failed in their duty of care to another. And rather that duty was to be owed to the plaintiff themselves, and that was a duty to avoid causing them an avoidable, reasonable, foreseeable shock. And then of course Judge Egan confirmed that in respect of criterion 5, the Glencar principles applied, which are foreseeability, proximity, and the absence of public policy considerations to contradict that, and also fairness, justice and reasonableness in imposing a duty of care. And the court had regard to the more recent cases of Morrissey in the HSE and Sheehan and Bus Éireann, and agreed that as those cases had applied Glencar, it would apply here also. And then the consideration moved to whether reasonable foreseeability had a particular meaning in nervous shock cases. And Judge Egan considered that it does have a specific meaning, that the plaintiff must show a reasonably foreseeable risk that specifically some form of psychiatric injury rather than a personal injury would result. And that was, she said, in line with Kelly and Hennessy. And the defendant didn't actually dispute the foreseeability of the psychiatric injury to the plaintiff. And certainly the court accepted that the defendant ought to have foreseen that negligence in diagnosing the cancer could have led to grave consequences for the plaintiff, but foreseeability alone couldn't satisfy Glencar. And proximity really proved to be quite a complex issue in this case. The defendant relied on a recent UK case of Paul and Wolverhampton NHS, and that was a proposition where essentially there was no duty of care between a doctor and a relative of your patient, and indeed that that type of a duty fell completely outside of the normal nervous shock realm. And nonetheless, the judge found it crucial that the UK Supreme Court in Paul determined that medical crises weren't analogous to the kinds of accidents on which nervous shock jurisprudence had been based. Now, having said that, neither party in Germain actually argued that medical crises fell outside of the nervous shock paradigm, and both approached the case as one of nervous shock. And so when the defendant attempted to argue that this broader negligence applied versus this more specific type of proximity in nervous shock cases, their own argument was undermined by that, because the UK Supreme Court in Paul was actually applying these broader based principles. And the plaintiff then took the more classical approach, where there had to be a physical and temporal, spatial, kind of a relational proximity to the event itself. And then that was actually more in line with Alcock and McLaughlin versus O'Brien as well. And then the court finally embarked on a consideration of nervous shock in England and Wales and the concept of secondary victims there, and noted that by the time of Kelly and Hennessy that those control mechanisms had already been levied on bystanders in the UK. And the court did note that the question as to whether proximity in a nervous shock action is different to a freestanding proximity wasn't actually fully argued by the parties, unfortunately, in Germain. And Judge Egan considered that the Irish authorities provided pretty much little guidance as to how the person, little guidance as to whether proximity could emerge from factors such as proximity to the person injured or proximity to the sudden shocking event. And the court posited in that regard that criterion 5 could encompass a confluence of proximities, and that the greater this confluence or knitting together of proximities, the more likely it could be that a duty of care might exist. And in any event, the judge did find that the proximity couldn't be established by an assumption of responsibility approach, as despite the plaintiff having attended all the consultations with her husband and a letter of disclosure having been written to her by the relevant consultant, that a separate duty of care owed by the consultant to the plaintiff had arisen at an earlier point in time during the provision of medical care to the deceased. It just wasn't stateable. And Judge Egan also highlighted that a duty of care to non-patients could possibly arise in cases such as a failed vasectomy or an infectious disease, or where a doctor acquires some type of knowledge where a patient is abusing a child, something where there is some duty that is owed to someone outside of the patient also. And the judge also determined in that regard that her finding that a duty of care was not established wouldn't be altered by the application of specialised proximity considerations, and relational and spatial and temporal proximity, or the confluence of them, and pointed out that fairness and reasonableness in imposing a duty of care was also required by Glencar, which is a context-driven analysis. And finally, Judge Egan also suggested that a general requirement that a doctor consider the health of their parties other than patients is likely to give rise to unintended consequences. And this was essentially a type of floodgates argument, and definitely worth noting the observations of the court in that regard. And certainly I think the court did really go out of her way to volunteer a number of these considerations, and hopefully that will guide the trajectory of the law in this area in the future. In particular, Judge Egan said, and I quote, that doctors must be taken to know that their patients' relatives might foreseeably be negatively impacted by witnessing the result of clinical negligence on the doctor's part. And if these factors alone establish not only proximity but also a duty of care, the number of potential plaintiffs in the medical negligence action could be multiplied by the number of potentially impacted family members. And that would obviously be disastrous in terms of the medical profession. And Judge Egan also noted that a general requirement that a doctor consider the health of parties other than the patient is likely to give rise to unexpected consequences and to wide and uncontrolled liability. And the judge finally noted that doctors are not obliged to shield relatives of patients against the risk of psychiatric illness in witnessing the deterioration of a loved one in an unprepared manner, that this is not a risk which doctors ought to have in their reasonable contemplation when directing their mind to the medical care of our patients. And Germain didn't really give us the type of solid answers we would have liked in respect of bystander medical negligence, nervous shock type cases. But the court seemed to be particularly exercised by this floodgates issue, and this indicates that should proximity and the duty of care arise for future consideration, there is a fair chance that the court might rely on the third and fourth elements of Glencar to avoid the imposition of a duty of care. And I think just in the general sphere of medicine, There's been a lot of commentary recently on the effect that this wild and uncontrolled medical negligence litigation is having on doctors and their ability to actually perform for their patients, and certainly the actual care that's delivered to the patients themselves. So I think certainly some type of control on this area to stop the floodgates opening will be very, very that would be very welcome to all parties indemnifying medical professionals, and also to the doctors and the patients themselves ultimately. But I think that's all I have to say on that. Okay. Thank you.
Any questions? No? No. Thanks, Gillian. It was my fault Gillian got up to the podium here before I got a chance to introduce her properly, but anyway, apologies for that. We're delighted our last speaker has managed to get here on time. Jeremy Maher SC, a long-standing senior counsel and chair of the Tort and Insurance Bar Association, so we'll be all very interested to see what he has to say here today in relation to the judicial guidelines and how the Supreme Court views them. So, Jeremy, thank you.
Thank you very much. So you're absolutely right. It looked like it was going to be a bit difficult to get here, but in fact, the way things turned out, it proved to be a much better idea to walk here rather than to try and get a taxi. So I walked here. It was actually lovely, and I think it's between showers. So one of the things as a barrister that you kind of fear is the prospect of appearing in front of a 7-man Supreme Court. Well, I think now that I'm going to have to add to that the prospect of appearing in front of 40 very experienced people in the insurance industry, many of whom I see and I know very well. And thank you very much to the committee for asking me to speak here today. When I was listening to Gillian talking about the decision, and so well she spoke about it too, because I've been looking at that decision for a long time and I couldn't make head nor tail of it, so thank you, Gillian. One of the benefits of these meetings is that you actually get feedback if you're a contributor as well as a listener. So I think it's no secret to any of us here that the march in personal injuries damages has been down for at least 15 years. I personally date it back to the introduction of the Court of Appeal. I think the Act was passed in perhaps 2012 and it came into being in 2014, and we all saw a steady stream of decisions in which the Court of Appeal reduced in a significant way awards from the High Court. Many of you here will have been aware of the decision. Nolan and Werensky is a good decision. That was a decision where Miss Justice Irvine really criticised the trial judge for failing to engage with the evidence and failing to recognise the fact that at heart what the court was trying to grapple with was a soft tissue injury case. And that continued through a number of other decisions. Many of you here, I suspect, were personally involved in them. And then it culminated in the introduction of the judicial guidelines. Now, the judicial guidelines, as you probably all know, have been extremely controversial in the sense that the judges themselves were at war in relation to their introduction. Some felt it was inappropriate, some felt it was appropriate. And I understand, and this is only apocryphal, that many of the people who voted for the introduction of the guidelines were district court judges who frankly wouldn't have much experience in relation to the conduct of litigation. So we have the judicial guidelines, and if they were devised as a technique of improving consistency in the award of damages by judges of the High Court, I think they have clearly succeeded. And but if they were brought into being with the intention of ensuring that soft tissue injuries were brought in the circuit court, they have succeeded. But here's the thing, and this is one of my propositions, and it may not be popular to say it, but I have to say it. I think it was never envisaged that the level of damages that would be awarded for what we would all have regarded as serious injuries, it was never envisaged, in my opinion, that they would be hammered in the way in which they're hammered in the judicial guidelines. I'm just going to give you an example. So there are probably 40 or 50 people in the room here today. Some of us are wearing glasses, some of us are not wearing glasses. but each one of us will be acutely conscious of how important our eyesight is for us. There is a decision of the Supreme Court in, I think it's 2001, a case of Paul Rossiter versus Dunleary County Council. And in that case, Paul Rossiter was a young boy, I think he was 10, and he had lost the eyesight in one eye. And he'd lost the eyesight in one eye because a piece of wire attached to a moor had come out of the moor when it was being used, and he lost the eyesight in that eye. There is, I think we'd all agree, there is a really serious injury. And this came before Mr. Justice Johnson. I'm not sure if he was the president of the High Court at the time, but certainly he was the very senior judge in the personal injuries list, and he assessed general damages in that case in the sum of £120,000. Now, £120,000 in 2001 was a lot of money. Plaintiff's counsel, my good friend Liam Reedy, said that's not enough to compensate a young boy for the loss of an eye for the rest of his life. And they took the decision, which was a fairly brave decision, because the Supreme Court has never exactly been known for its sympathy to litigants in the personal injury side. They took the decision to appeal the decision to the Supreme Court. And perhaps somewhat surprisingly, but certainly it occurred, the Supreme Court, in the judgment, I think, of Mr. Justice Fennelly, increased the general damages from 120,000 to 150,000. Now, bear in mind, we're talking about Irish pounds. The value, it was worked out recently, the value of that decision in terms of euros would be somewhere in the region of 175,000 euros. So let's imagine that when the Supreme Court reached its decision in respect of the loss of an eye in 2001 or 2002, it awarded 175,000 euros by way of compensation for the loss of an eye. Think what that would have bought at the time. How many cars could you have bought? How many houses in Dublin could you have bought? And now look at what the judicial guidelines have done. It is extraordinary, in my view, that the value of an eye is now, according to the judicial guidelines, worth between 80 and 120,000 euros. Now, if there's a member of the audience here who would give up their eye for 120,000 euros, I'd like to know. Because, let's be honest about it, none of us would. In fact, if anything, we'd be looking for 500,000 euros at least for that kind of loss. But that's what the judicial guidelines have done. I'm not here to criticise the judicial guidelines, but I am here to point out that it does give rise to a significant risk of injustice when it comes to the big injuries. None of us here, I'm sure, and myself included, have any particular problem with soft tissue injuries being rewarded with the appropriate level of compensation that is provided for in the guidelines. But when it comes to the big injuries, can I suggest that different considerations could apply? Now, one of the things, and I've heard people say this, is that they're only guidelines. And the court can, of course, depart from the guidelines, and that is what the guidelines themselves say. But what they say is that in assessing damages, a court is obliged to have regard to the personal injury guidelines. That's very similar to what the Book of Quantum said, we'll all recall. But then it says, where the court intends to depart from the personal injury guidelines, it must state the reasons for such departure. Now, that would require a considerable act of courage by a judge to set out why he thinks or she thinks the guidelines are not appropriate. And I'm not aware of any case where that has happened to date. It may have, but I'm personally not aware of any case where it has happened. Now, into the mix comes the Delaney case, the Delaney and the Pyab case. Why this case was brought, I do not know. It was brought, I presume, in the interests of a particular litigant, but let's face it, it was an injury of a minimal nature. And the Supreme Court have been asked to grapple in the context of the constitutionality of the personal injury guidelines with a case involving a bit of an injury to an ankle. Would the result have been the same if the Supreme Court had been asked to look at a case involving, for example, someone losing their leg, someone losing their eye, someone losing their arm, someone losing their hand? I suspect not. But we're now, unfortunately, from the point of view of all of us in a sense, we're now stuck with it. The Supreme Court found, as we know, that the guidelines were constitutional, and did so because of the incredible intelligence and foresight of some official in the Attorney General's office who said, apparently, I'll tell you what we'll do. To make sure these are constitutional, we'll shove them into the Family Leave and Miscellaneous Provisions Act of 2021. Now, what the judicial guidelines have to do with Family Leave and Miscellaneous Provisions Act of 2021 is unclear, but that was the mechanism by which these guidelines have been found to be constitutional. And I'm just talking about a few of the other, trying to analyse why the guidelines are so successful. Well, one of the things they have done, I think, is that they have recategorised the injuries that we have to look at. So let's imagine a situation in 2017 and any one of us were asked to do an opinion for an insurance company in relation to, for example, a compression or crush fracture to the lumbar vertebrae with a substantial risk of osteoarthritis and a significant level of ongoing pain and discomfort. Now, personally speaking, and maybe I was negligent in so advising, I hope not, I would have said that that's a case probably worth 75 to 100,000 euros at least. What do the guidelines say? The guidelines say that that type of injury is to be classified as having a value band of between 35,000 and 55,000 euros. So one of the extraordinary mechanisms in which the guidelines have succeeded in reducing damages is because they have recategorized the injuries. They've called the injury I've just outlined to you the crush fracture with all those sequelae, three elements really: the crush fracture, the substantial risk of osteoarthritis, and the significant level of ongoing pain and discomfort. That is now what is called a moderate injury. It is no longer what we would have considered previously to have been a serious injury. And even if you look at the guidelines and compare them to what the Book of Quantum provided, that's the Book of Quantum from 2016, similar description of an injury. In there they describe it as a serious or severe and permanent injury to the back. The value band was 52,300 to 92,000. So effectively, what has happened is that the value bands have been have seen a 50% reduction in the value of an injury. Now, as I say again, perhaps that's fine with soft tissue injuries, but is it appropriate in injuries of this nature? I understand that the insurance industry has significant concerns in relation to damages, but I also understand that a more significant concern is in relation to costs, and that's totally understandable. And I'm sure that's why the first speaker here today spoke about costs. But should the citizens of Ireland who suffer genuine injury have to suffer as a result? So that's the party political broadcast bit over. And now I want to get on to the issue of how do you go, accepting of course that the guidelines apply, how do you actually assess the injuries? And because I'm one of the old-fashioned counsel, I brought with me copies of the paper, so you don't have to, that I'm delivering, you don't have to write anything down unless you want to, of course. But so the guidelines themselves provide the guidance as to what you do. And the first thing you do is you identify the dominant injury, the injury which is the most significant injury. And you then, having identified the dominant injury, then look to see where does the dominant injury fit into in the categorization. So that's firstly identify the dominant injury, secondly find the categorization into which you put it, and thirdly you then have to consider where does it fit in within that value band provided in the categorization. So it's a very clever, very well drafted document because it covers a multitude of situations and it requires counsel, solicitors, whoever is making the submission to the court, and that's something I'll come back to in a second. It requires the person making the submission to identify the dominant injury, then secondly to identify the category, and then thirdly to identify the location within that category that it fits. So it might be that a legal practitioner says, well, this is the dominant injury here is a fracture to the elbow. It comes into the moderate category, but judge, it comes within the most severe end of the category of that type of injury. and that's the way it should be done. Now there have been developments in relation to multiple injuries. There are two decisions which I've referenced in my paper which are interesting. One is the Zaganchik case, and the other is a more recent case of Collins versus Parma, which was delivered, I think, just before the summer break in the last legal term. So if you're dealing with multiple injuries, in addition to having identified the dominant injury, its categorization and its location on within the categorization, you then have to look at each of the other injuries. So, for example, let's say that in addition to the fractured elbow, there was also perhaps a broken finger or something of that nature. You then have to look at that injury, see where it fits in the categorization, and then see where within the category does it fit. Is it low, middle, or is it at the higher end? And you do that then in relation to each of the injuries. And that could, for example, result in, let's say there were 4 injuries and you could get the dominant injury, say 40,000 euros, and then you could get each of the other injuries together cumulatively amounting to 30,000 euros. So in theory that would give you 70,000 euros by way of an award. But the guidelines are clear about this, and the Court of Appeal has now been very clear about this. The judge in question does not simply conduct a mathematical exercise. The judge must ensure what is known as proportionality. And proportionality, which is a buzzword at the moment in litigation, it would appear, essentially means, in the context of general damages, you must reduce the non-dominant injuries to arrive at an overall figure which is fair and reasonable to both sides. And it looks to me as though the recent jurisprudence of the Court of Appeal, and indeed decisions of the High Court by Mr. Justice Coffey, indicate that firstly you should identify the dominant injury, then you look at the multiple injuries, give them a value, add them up, and then take off a percentage. The percentage which seems to be in vogue at the moment is 1/3. That's the so-called reduction because of what is described as temporal overlap. So that's the way you do it, and you arrive at a figure which is then fair and reasonable. And I have to say, I have no difficulty with any of that, because I think that's fair. You must it's sometimes misunderstood by legal practitioners that the purpose of general damages is simply to tot up all the injuries and to give a figure at the end of it. It's not. The figure must be fair, the figure must be reasonable, it must be fair and reasonable to both sides, to both the plaintiff and to the defendant. And that's why I think it's entirely appropriate that the court has a reduction for the non-dominant injuries. Now the reason I said I'd come back to this is, in the Collins and Parma case, which is a decision of the Court of Appeal this year, and a decision, by the way, in which the court reduced an award of 90,000 odd to a figure of 55,000 euros. The Court of Appeal was very critical of counsel on both sides of the case, and the criticism was that they hadn't given guidance to the judge in relation to how the guidelines should be approached. And that, for me, emphasises the fact that it's incumbent on any of us who are doing cases in front of any judge to say, this is where they fit in, this is the categorisation, this is what we say is the appropriate case, and also, if necessary, to reference the case law. And in fact, in Collins and Parma, the Court of Appeal was also obliquely critical of the trial judge for not engaging in this type of exercise as well. So this is in fact a bit of a sea change, in a sense, to the manner in which judges have to carry out their duties. But the one thing that it reinforces is the obligation on those who are appearing in front of any judge to identify where exactly the injuries fit in. Now that feeds into the work that everyone here in this room does, because that means that when you are asked to do an opinion for an insurance company, you should, I think at least, you should say, in my opinion, the following is the dominant injury. You should probably identify by reference to a medical report where you're getting that from, and then you should say these are the other injuries, and allowing for the temporal overlap, I think that the appropriate figure that we should end up is this figure. And I suspect that your principals will be very happy with that type of advice early on, because it can be pretty difficult to find out about it late in the day. The case of Agnieszka Zaganchik and John Pett at Wexford Unlimited Company is a case from last year, 2023. It's referenced in the paper. I brought physical copies with me, but I think Declan can make available to anyone who wants them online. So in that case, the Court of Appeal were faced with an award of €90,000, and they reduced it to €60,000. Now I think, subject to correction, that the judge was Mr. Justice Hanna, and I'm not sure if Hayes McGrath were in the case or not in the case, but in any event it was a happy result for the defendant in the case at the end of the day, with very unhappy results, I think, for the plaintiff's legal advisors, particularly when it comes to the issue of consequential cost orders, because of course the consequence can be, if you get too well in the High Court, appeal to the Circuit Court, you're likely to lose the costs of the Circuit Court, of the Court of Appeal, and you might well lose the costs of the High Court. But anyway, that's another day's work. But in this particular case, the plaintiff was a chef, and she was working in Waterford in, I think, a delicatessen owned by SuperValue, and she was engulfed in flames when an oven in her place of work exploded. And so she had what were really, I suppose, psychiatric injuries, and there was also an element of scarring and burning. She had, I think, burn injuries to the left side of her face, to her neck, and to her left ear, and also some on her left arm and to her hand. But what's interesting about that case is that they didn't adduce any medical evidence on the psychiatric front, and I think Elizabeth Cryan was the lead expert for the plaintiff, and she herself had indicated that the plaintiff had recovered within about 30 months. Now that's a significant factor to be taken into account when you're looking at value bands and categorizations for the issue of injuries to the mental psyche. So the judge looked in that case at the psychiatric injuries, and he found that there were two psychiatric injuries. The first psychiatric injury he found was that there was PTSD. He identified that as the most significant injury, and he attributed a value to that of, I think, €45,000. And he was clearly in error in that, because to get into that categorization, you'd have to be a severe injury. This was not a severe injury according to classifications. This was at most a moderate injury. So that was the first criticism of the trial judge. The second criticism of the trial judge was that he had regarded the fact that the plaintiff had a mood disorder and a problem with alcohol for a bit of time after the accident as justifying a separate award for mental illness. And the reason for that is, if you look at the guidelines, I'm sure we all have, when you come to mental illness, there are two categories. One is PTSD and one is psychiatric injury. The judge in this case was criticised for not regarding the alcohol problem and the mood disorder as being within the PTSD. And the reason for that is that PTSD includes mood disorder. Now, looking at it from the judge's point of view, you can see, well, the psychiatrist has told me that there are two distinct psychiatric injuries. The Court of Appeal did not agree with that. Court of Appeal took, I suspect, what you could consider to be a rather old-fashioned view of mental health issues and said there's only one real injury here, that's the PTSD. And for that reason, they said there should have been no award, separate award, for the alcohol disorder and the mood disorder. And they only gave damages for the PTSD, and they gave damages under that heading and that heading alone of €35,000. Now, what do they do then? And this is the really strange part about this judgment. And I've been trying to figure it out myself, because if we apply the recent case law, and I'm talking here about the Collins and Palmer case law, they should have looked at the other injuries and they should have given them a value, and then they should have reduced it because of the temporal overlap. But they didn't actually do it in that case. It may be that at that time the Court of Appeal hadn't cottoned on to the idea of this reduction because of the temporal overlap. But anyway, what they did is they didn't touch the scarring and burning element to the case. They just left it alone. So the overall award for scarring and burning, which had been scarring as a result of the burning, had been decided upon by the trial judge at €25,000, and they left it there. So that part of the judgment was not interfered with, which is, in my view, now a little bit of a surprise given what the recent case law has said. If you're trying to look for a very good example of the way in which a High Court judge should conduct his or her task, then look at the decision of Mr. Justice Coffey in the case of Keogh versus Byrne. That's a decision from 2024, IEHC 19. Now that's an interesting decision. A policeman was the injured party. He got a very bad fracture of the shaft of the radius and ulna of his non-dominant left forearm, and then also a fracture of his right wrist, and he had some bruising of the testicles, and he had some minor soft tissue injury to his thighs, chest and ribs. Mr. Justice Coffey heard the case, and he looked at the radial injury as being the dominant injury, and looked at that and he said that's a severe injury, and he gave 55,000. He then looked at the injury to the right wrist, and he said, well, that's an injury to the right wrist which straddles the divide between serious and moderate, and he said that's a value of 42,000. And then he looked at the other injuries, the testicular injury and the soft tissue injuries to the neck, etc., and he said that's worth 3,000. So if you were to total those sums up, you'd come to a figure of €100,000. But Mr. Justice Coffey, and this has been approved in a number of decisions, said, no. What you have to do then is you must discount the non-dominant injuries, and he discounted it by a third. And that meant that the award was €85,000. And that is an exemplar for how to conduct how to construct the award of damages applying the judicial guidelines. One final thing I wanted to say, and it's this, and that is that I think that the judicial guidelines have essentially heralded the end of soft tissue injury cases being brought in the circuit court. Being brought in the High Court. Anyone who brings a case in the High Court involving soft tissue injuries is very brave. And the reason I say that is because, and I see these letters all the time, letters from very senior and respected, and quite correctly so respected, members of your profession saying, we believe this is a case which should have been brought in the circuit court, and we want you to know now that we will be looking for a cost differential order in due course when you fail miserably to, they don't put that word in, when you fail miserably to get an award in the jurisdiction of the High Court. And those letters have real effect. They have a real salutary effect on at least counsel advising plaintiffs in litigation. And I think they're very appropriate and a very successful way of dealing with cases that should never be in the High Court in the first place. So the message I have to everyone here is that it's more good news. Damages are going down. Whether that's fair or not is not for me to say. I may have my own views about that. Damages are going down. It's a matter for others than people other than us here today to consider whether premium are going down or going up. I don't know. But it is certainly a fact that 3 years have elapsed since the judicial guidelines. I am unaware of any decision in that time when the Court of Appeal have increased damages awarded at the High Court level. And the one caution I have to all of this is that the judicial guidelines have to be revised, as everyone knows, every 3 years. And it's not just one time only after, in other words, April 2024, because they came in on the 21st of April 2021. They have to be revised every 3 years into the future. It hasn't been done yet. I gather it has been done. Whether we will ever see it, given the fact that government have their eyes on other issues at the moment, is a moot issue. But if it's not done, I can well imagine a judge saying, well, these are guidelines which came from 2021. Things have changed since then. Inflation has moved on. Prices of houses have gone up. I'm going to add on my own view of what should be added to reflect the changes in the economy since that time. So watch this space. Thank you.
On behalf of Foil Ireland, I'd like to thank our three speakers, Nora, Gillian and Jeremy, for some very insightful points there in relation to the three separate topics. We're always very, very interested in issues of costs, and while I'm not a personal injuries lawyer, the nervous shock points and the judicial guidelines are very, very interesting, and I hope all three speakers can stay with us for a while so we can collectively pick their brains a little bit further. We have a reception outside, so hopefully you can all stay around for that as well. As I said earlier, we are looking at further CPD events, both online and hopefully a number of more in-person ones. We certainly have some of the pipeline, but I just thought I'd take an opportunity, considering we have a number of our members here, and you all have your own thoughts, views and everything else in relation to what we might want to speak about or which we should speak about. So perhaps you can all have a think about that and either give your views this evening, or you can certainly email into Foil Ireland in terms of topics that you might like to hear at future Foil events. So once again, thanks everybody for attending, and I just want to hand over to Lawrence Bessemer from Foil UK to say a few final words. Thank you.
Thanks, Noel. I just want to say thank you, everybody, for coming along. I know it's been a little bit warm in this room. Hope you're not too uncomfortable. There is a drinks reception next door, so you go out of here, turn right, and then it's on the right door on the right-hand side. So thank you for that. Just to follow up from what Noel was saying, we will send out a post-event survey, and one of the questions on that will be, what else would you like us to organise a talk on? But you can still, just send us an email at any point if something comes up that you want us to talk together on. You can follow us on social media. We're on LinkedIn only now. We were on Twitter and Instagram and all the others, but felt a bit too much like hard work in the end, trying to keep all those plates spinning. So we're just on LinkedIn. That's the professional network, and I think that's correct for Foil as an organisation in terms of social media profile. CPD, I'm sorry that it was a slightly amateur piece of paper that we passed around, but hopefully everybody signed that. If so, we'll send you your CPD certificate next week, I should think. I think that's all I need to say, really, isn't it? So I will just say a quick thank you to Noel, who's been the president for 2 years now, and he's kindly agreed to stand for a third term. So I think a little round of applause for that. Just to say, this has been filmed. It hasn't been streamed, but it has been filmed. So the film will be available on our website sometime next week, I hope. But thank you to the cameraman at the back for doing a quiet, but I'm sure excellent job. Thank you very much. And I hope you're all going to join us for a drink.
Cheers.